Perfect. So when Zoom sends me the recording, I will email it out to all of the attendees along with the slides for you to review later as you wish. So page 1. So number 1 will be the terms and definitions. So make sure to put all of the sellers listed under sellers and all of the buyers in B. And let's see, C is property. So it's not just the land and buildings, but also everything that goes along with that. Select if the property will or will not include a manufactured home. Select if the property will or will not include an off-site boat slip, garage, parking space, or storage unit. Now, the property description, you are going to list just the property address here. There's a note reminding you that factors like taxes, zoning rules, school districts, utilities, and mail delivery might vary from what's listed for the property. Now, for the legal description, you'll fill out everything applicable, and you can find this information on the county website where the property is located. Section D goes over the purchase price. So you're going to list the purchase price of the property. It does not have to be the list price, and it's based on the following terms. Due diligence. So you're going to select how you will submit: cash, personal check, official bank check, or wire transfer, and an initial earnest money deposit. This is going to be made within 5 days of the effective date. Select how you will submit: cash, personal check, bank check, or wire transfer. Number 4 is any additional earnest money. You're going to list any additional funds that your buyer is willing to contribute. And then the buyer assumption is when the buyer agrees to take over the remaining loan amount and any other financial responsibilities that the seller has on the property's existing loan. This agreement follows the terms outlined in the loan assumption addendum, which is standard form 2A6-T and is attached to the contract. So you'll list the amount here. Number 6 is seller financing. You're going to list the amount the seller is financing on their loan. And number 7, building deposit. If buying new construction, you're going to list the amount of the builder deposit. And number 8 is the balance of the purchase. All right, page 2. So if the buyer doesn't pay on time or their payment bounces, they have 1 banking day after getting written notice to pay with cash, an official bank check, wire transfer, or electronic transfer. If they don't pay on time, the seller can cancel the contract and keep any fees already paid. The seller can also seek legal action for the bounced payment. Details about legal fees related to payments are in paragraph 23 of the contract. And please note that if the buyer and seller decide to use electronic or wire transfer for any fees or deposits, the seller will help facilitate the transfer. This includes setting up and required accounts and providing necessary information to the buyer. However, the buyer is responsible for any extra costs associated with this type of transfer. E talks about earnest money deposit. So this includes the initial earnest money deposit, any additional earnest money deposits, and any other earnest money payments related to the deal. These funds are held in escrow by the escrow agent. The escrow agent, whose names should be inserted into the contract in F, is responsible for holding the earnest money deposit in escrow. Both the buyer and seller agree that the escrow agent can share important information about the earnest money deposit with the parties involved in the transaction, including their real estate agents and the buyer's lenders. Please note that if there's a disagreement between the buyer and seller regarding the earnest money deposit, a licensed real estate broker or escrow agent must keep the earnest money deposit in their trust or escrow account until they receive written agreement from both parties on how to handle it. If a broker or an attorney is holding the earnest money deposit and there's a dispute, they may deposit the disputed funds with the court clerk as per North Carolina law. The agreement states that if a real estate brokerage firm acts as the escrow agent, they can put the earnest money deposit into an interest-bearing trust account. Any earnest money on this account will be given to the escrow agent every month. This arrangement compensates the escrow agent for the costs of maintaining the account and handling related records. And please note, Dalton Wade does not hold earnest money, as do many real estate offices. So the effective date is the date when both the buyer and seller have signed or initialed the offer or final counteroffer. And this signing or initialing has been communicated to the other party. The buyer's opportunity to investigate the property and the transaction to decide whether to proceed or terminate the deal is due diligence. There's a due diligence fee, which is an amount paid by the buyer to the seller, granting the buyer the right to terminate the contract during the due diligence period. The fee becomes the seller's property upon the effective date and is credited to the buyer at closing. The fee is non-refundable, except in specific circumstances outlined in the contract. Both parties waive rights related to the fee's absence or amount, aiming to create a legally binding contract regardless of the fee. The due diligence period is the time starting from when the contract becomes effective until a specific date and time, usually 5 p.m., when the buyer has the chance to investigate the property and the deal. It's crucial to stick to this deadline. K discusses settlement, and this refers to completing all the necessary paperwork and providing the required documents to the closing attorney to finalize the transaction. It includes things like the deed, settlement statement, and loan documents, and ensures all the funds needed for the transaction are available. Page 3, the settlement date. This is the date when all the final paperwork and transactions related to the property sale will happen. It's typically agreed upon by both parties unless there's a written agreement to change it. The buyer usually chooses the time and location for the settlement. Closing. This is when all the legal steps are completed to transfer ownership of the property from the seller to the buyer. It includes settling the paperwork, updating the property's title, authorizing funds, and recording the necessary documents in the county registry. The closing attorney disperses the sale proceeds as per the settlement statement and North Carolina laws. If there are unexpected issues with the title or funding, the closing may be delayed. There's a warning here that states that in North Carolina, many tasks involved in a property closing are considered legal services and must be done by a licensed attorney. Non-attorney settlement agents can handle some aspects of a closing, but not everything. Since closings involve legal matters, it's recommended that all buyers hire a licensed North Carolina attorney for their closing to ensure that everything is handled correctly. Special assessments. These are additional charges imposed by a government authority or an owner's association on top of regular taxes or fees. They could include things like specific property taxes or fees for community services. These assessments can become liens against the property. Number 2 is fixtures and exclusions. So this warning advises against assuming whether an item will or won't be a part of the sale based on verbal or written statements not included in the contract. It emphasizes the importance of being clear and specific during negotiations about which items will be included or excluded from the sale. All existing fixtures are included in the purchase price, so that would be A. They are free of any liens unless specifically excluded in subparagraphs D or E. B covers specified items. So this part of the contract outlines that specific items agreed upon by the buyer and seller will be included in the sale as part of the purchase price, provided they are present on the property on the offer date. These items are free of any liens unless they are excluded in subparagraph D or E of the contract. It's noted that these items can include both traditional and smart versions, along with any dedicated or related equipment and remote control devices associated with them. See the list on contract for specifics. And C covers unpairing or deleting data from devices. So before the closing date, the seller must disconnect or unpair any devices that are part of the personal property being sold, such as, mobile devices, vehicles, virtual assistants, Nest, Ring cameras, etc. Delete any personal data from these devices and restore them to the original factory settings unless there's a different agreement in place. These responsibilities of the seller continue even after the closing date. Please note that any fixture or item listed in subparagraphs A and B that will not be included in the sale must be clearly identified in subparagraphs D or E of the contract. This ensures clarity and avoids misunderstandings about what is included or excluded from the sale. D is leased or non-owned items. Any items that are leased or not owned by the seller, like antennas, satellite dishes, receivers, appliances, alarm and security systems, and any leased fuel tank identified in paragraph 7D should be listed here and will not be part of the sale. E covers other excluded items. So any additional items not mentioned in subparagraphs A and B that the seller does not want to convey in the sale should be identified here. The seller is responsible for repairing any damage caused by removing these excluded items in a proper manner and must inform the buyer when these repairs are completed, providing documentation if necessary. Please note that if the buyer has specific requests regarding how the repairs for excluded items should be done, they should consider attaching the additional provisions addendum to this contract. This addendum allows for more detailed instructions or agreements regarding repairs, providing clarity and ensuring both parties are on the same page. 3 covers personal property. So you're going to list any personal property that will be transferred to the buyer at closing without assigning a value to them. Please note that any items included in the sale should be clearly listed. It's also a good idea for the buyer to check with their lender to make sure that the listed personal property can indeed be included in the contract. Number 4 is the buyer's due diligence process. So the buyer can apply for and get approved for a loan if needed at their own expense. There's a note that clarifies there's no provision in the offer to purchase and contract for a loan or appraisal contingency. Therefore, it's advised that the buyer talk to their lender before signing an offer. This consultation is important to ensure that the due diligence period allows enough time for the loan process and for the lender to provide the buyer with sufficient information to decide whether to proceed or terminate the transaction. B covers property investigation. The buyer or their representatives can conduct various checks and inspections on the property, which include inspections, checking the property's condition, drainage, moisture issues, presence of asbestos, or any environmental problems such as radon gas or insects. Review of documents, looking into the property's governing documents like covenants, bylaws, and rules of any homeowners association. Insurance, checking availability and cost of insurance for the property. Appraisals, getting an appraisal to determine the property's value. And survey, examining the property's suitability for the buyer's planned use and checking for any issues with easements, property boundaries, or title defects. Zoning, governmental regulation, and governmental compliance. investigating zoning laws, government regulations, and compliance issues that might affect how the property can be used. And flood hazards. Assessing potential flood risks on the property and any need for flood insurance. Utilities and access. Checking availability, quality, and maintenance responsibilities for utilities like water, sewer, electric, gas, and communication services. And streets and roads. Investigating the status of streets or roads leading to the property, including whether they are public or private, who maintains them, and any agreements related to their upkeep. Special assessments. Check if there are any special assessments being considered by a government authority or owners association for the property. C, sale or lease of existing property. This contract isn't dependent on the sale or lease of other property owned by the buyer. If the buyer needs to sell or lease other property to qualify for a new loan or complete this purchase, they should aim to close on their property before the due diligence period ends. This ensures that the closing will happen before the settlement date. And repair improvement negotiations. The property is being sold as is unless the parties agree otherwise. The seller may or may not negotiate repairs or improvements. If the buyer wants repairs or improvements, they should make their requests early enough to allow time for negotiations before the due diligence period ends. Any agreements on repairs or improvements must be in writing and signed by both parties. E, the buyer's obligation to repair damage. The buyer must promptly fix any damage to the property caused by them, their agents, or contractors, except for damage caused by accepted practices or licensed professionals doing appraisals, tests, surveys, or inspections. This repair obligation continues even if the contract is terminated. F, indemnity. The buyer agrees to compensate the seller for any losses, damages, claims, suits, or costs resulting from the buyer's activity on the property, except for losses due to pre-existing conditions or the seller's negligence or intentional acts. This indemnity continues even after the contract ends. And the buyer's right to terminate. The buyer can cancel the contract for any reason by giving written notice to the seller during the due diligence period. If they do so, they get their earnest money deposit refunded. And condition acceptance at closing. Unless stated otherwise, in writing, closing the deal means the buyer accepts the property in its current condition. Number 5, buyer representations. A, funds to complete the purchase. So check which option is applicable. So cash. The buyer will pay with cash from their own assets without a loan or other external funding. They may need to provide proof of available cash for closing. If the buyer doesn't plan to get a new loan or use funds from sources other than their own assets, the seller should ask for proof that the buyer has enough money to buy the property without a loan or external funds before signing the offer. B, loan or other funds. If the buyer plans to use a loan or other funds, they specify a first mortgage loan, which is an FHA, VA, conventional, USDA, or other, the principal amount and any additional fees, and a second mortgage loan. So if applicable, details about a second loan, and other funds. If using funds from sources other than a loan, such as a gift or personal fund, those sources must be specified. Please note that the buyer's responsibilities in this contract don't depend on them getting a loan or funds from sources other than their own assets. If there are changes in how the property is funded that affect the contract terms, those changes must be shared as important information. Other property. This section asks if the buyer needs to sell or lease another property to get a loan or buy the property. If they do, they need to provide details about that property. If the other property is already under contract, they should share a copy of that contract with the seller. If it's not under contract, they can choose to list it with a real estate broker or try to sell or lease it without one. Check the section that is applicable. Please note that the contract isn't dependent on the sale, lease, or closing of the buyer's other property. If such a condition is desired, it should be discussed with a North Carolina real estate attorney who can draft a proper contingency addendum to be included in the contract. C covers the performance of buyer's financial obligations. The buyer confirms there are no known circumstances or conditions preventing them from fulfilling their financial obligations outlined in the contract. And residential property and owners association disclosure statement. So the buyer indicates whether they have received and complied with the North Carolina Residential Property and Owners Association disclosure statement. If not received, they have the right to terminate the contract within a specific time frame. Mineral and oil and gas rights mandatory disclosure statement. Similar to the residential disclosure, the buyer indicates whether the receipt and compliance with the North Carolina mineral and oil and gas rights mandatory disclosure statement has been received. So check if they have or have not received the disclosure statement or if they are exempt. Receiving the mineral and oil and gas rights mandatory disclosure statement doesn't change the seller's responsibility outlined in paragraph 8G. If the contract, so it also states that the buyer's receipt of this disclosure doesn't imply their acceptance or approval of any severance of mineral oil or gas rights, unless explicitly agreed upon and approved in writing by the buyer. Number 6 is the buyer's obligations. So A, responsibility for special assessments. The buyer agrees to accept any additional charges that may be approved after the property's sale is finalized. Responsibility for certain costs. If the buyer is responsible for paying certain expenses related to the purchase, including any loans they take out, fees charged by a homeowners association, costs for property appraisal and title search, insurance for the property's title, fees charged by the closing attorney for preparing documents, recording the deed, and any other necessary documents. And C, authorization to disclose information. The buyer gives permission for their lender, real estate agents, and closing attorney to share and disclose information about the purchase, such as the contract and financial details to everybody involved in this transaction. And the seller representations. So ownership. The seller confirms how long they have owned the property, if they have owned it for at least 1 year, if they have owned it for less than 1 year, and if they do not yet own the property. The lead-based paint disclosure. If the property is residential and was built before 1978, the seller needs to provide a lead-based paint or lead-based paint hazards disclosure addendum. The Owners Association and dues. A seller is given permission for certain documents related to the property and any owners association to be shared with the buyer, buyer's representatives, closing attorney, or lender. The documents include things like financial statements, insurance policies, rules and regulations, and other information about the association. If there's a specific association, its name, the regular assessments, and contact information for its president or manager should be provided. Fuel tanks or fuel. So this covers whether there are fuel tanks on the property and details about them if they exist. If there are fuel tanks, the seller needs to describe each tank, including its current use, ownership status, location, type of fuel, and contact information for the tank leaser and fuel vendor. The agreement between the buyer and seller regarding the inclusion of these tanks in the sale and the handling of any remaining fuel at the time of settlement is also outlined. Please note that the buyer has the right to inspect fuel tanks on the property to verify their existence, type, and ownership. Additionally, it's recommended that the buyer communicates with the owner of any leased fuel tank to understand the leasing terms and fuel procurement process. State law provides that it is unlawful for any person other than the supplier or the owner of a fuel supply tank to disconnect, interrupt, or fill the supply tank with liquefied petroleum gas without the consent of the supplier. C covers leases. This addresses whether the property being sold is currently under any lease agreements. If it is, then both the buyer and seller should include either the rental income investment property provision in the additional provisions addendum or the vacation rental addendum with the offer. Number 8 are seller obligations. So evidence of title, payoff statements, and non-foreign status. The seller agrees to provide all relevant title information such as insurance policies, attorney opinions, surveys, deeds, leases, and easements to the closing attorney promptly after the contract's effective date. The seller must also provide information required to obtain payoff statements from lenders regarding any loans on the property. If the seller is not a foreign person under tax law, they must provide a certification confirming their non-foreign statuses to the closing attorney. Failure to provide the non-foreign status certification may result in tax withholding as per the Internal Revenue Code. Authorization to disclose information. The seller allows their attorney, the property's title insurer, and the closing attorney to share relevant documents and information with the buyer, agents, and attorneys involved in the transaction. And access to the property. The seller must grant reasonable access to the property for inspections, repairs, verification, and final walkthroughs, including providing utilities and ensuring they are in working order. Removal of seller's property. Before possession by the buyer, the seller must remove all personal property not part of the sale, as well as any garbage or debris from the property. Affidavit and indemnification agreement. At settlement, the seller provides documents verifying payment to any contractors or suppliers working on the property, agreeing to indemnify the buyer against any claims related to unpaid debts. And designation of lien agent, payment and satisfaction of liens. If required by law, the seller designates a lien agent and ensures all outstanding debts or charges against the property not assumed by the buyer are paid before or at settlement. And good title, legal advice. The seller must provide a general warranty deed conveying clear title to the property, free from significant encumbrances or defects, and ensuring legal access to public roads. Government compliance. The property should be free from material violations of laws or regulations unless disclosed before the contract's effective date. If violations are discovered before closing, the seller may fix them, or the buyer can choose to proceed or terminate the contract. Home warranty. The seller and buyer decide whether a home warranty will be provided and who will pay for it. Options include no home warranty, the buyer purchasing one at a specific cost, or the seller providing one at their expense. And seller's breach of contract. So there's details here about what happens if the seller breaches or fails to fulfill their obligations under the contract. The buyer's rights and remedies in such a situation are outlined in paragraph 23. Charges by owners association. This section specifies who is responsible for paying different charges related to the owners association or management company. So the seller typically pays for certain fees related to disclosures and account information, while the buyer covers charges related to their lender, move-in fees, and covenant compliance checks. And that, let's see, we have a couple pages here. I skipped. Back a little bit here. Okay, here we go. All right, number 10 is prorations and adjustments. So taxes on real estate property. Ad valorem taxes and reoccurring government fees on real property are divided based on the calendar year, with the seller responsible for the portion up to the settlement date. Taxes on personal property. So ad valorem taxes on personal property are paid by the seller for the entire year unless the property is transferred to the buyer, in which case they are prorated based on the calendar year. Rent payments for the property are prorated up to the settlement date, and regular assessment dues are on similar charges by owners associations are prorated between the buyer and seller. Number 11 covers condition for property risk of loss. If the property isn't in the same or better condition at closing, except for normal wear and tear, the buyer can choose to cancel the contract and get their earnest money deposit and due diligence fee back. Risk of loss. If they don't cancel and the property is damaged, the buyer gets any insurance money that the seller receives for that damage. Number 12, the delay in settlement or closing. If one party is ready to close on the agreed upon date, but the other party can't, the party causing the delay must inform the other party and the closing attorney as soon as possible. If the delaying party doesn't complete the closing within 7 days after the agreed date, they're considered to have breached the contract, and the other party can end the contract and pursue any available remedies. Possession. This section specifies when possession of the property, including access and any keys or codes needed, will be transferred. Usually, possession happens at closing unless there's a separate agreement attached to the contract for possession happening before or after, or if there are any tenants currently living in the property. So check what applies. The addenda. This section asks to check any standard addenda that are part of the contract and attach them. It also allows for identifying and attaching any other addenda that are not standard. Assignments. This part states that the contract cannot be transferred to another party without written consent from all parties involved, except in the case of a tax-deferred exchange. If there's a written agreement for assignments, the contract is still binding on the new party and their successors. Tax-deferred exchange. If the buyer or seller wants to do a tax-deferred exchange related to the property sale, both parties agree to cooperate. However, the party initiating the exchange is responsible for the additional costs, and the other party doesn't take on any extra liability. Additional documents may need to be signed for this exchange, and various standard addenda are listed as options for potential inclusion in the contract. Number 17 covers the parties. This clause states that the contract is binding on both the buyer and seller, as well as their heirs, successors, and assigns. It clarifies that terms in the contract apply equally to singular and plural forms and to different genders when appropriate. Survival. Any provision in the contract that needs to be observed or performed after the closing date will continue to be binding and in effect until fully observed or performed. 19, the entire agreement recordation. This section confirms that the contract contains the entire agreement between the parties and that any changes must be in writing and signed by all parties. It specifies that the contract cannot be recorded without the written consent of both the buyer and seller. Additionally, it states that the contract does not alter any agreements between the parties and their real estate agents or brokers. Number 20, conduct of transaction. The parties agree that actions related to the contract, including signing and communication, can be conducted electronically. It also specifies how notices and communications should be delivered. Execution. The contract can be signed in multiple copies, and all copies together constitute one valid agreement. Computation of days or time of day. This clarifies how days are counted in the contract and specifies the starting point for counting days. It also specifies the time zone for reference in the contract. Number 23 are remedies. So A is breach of buyer. If the buyer breaches the contract materially, the seller is entitled to receive any earnest money deposit as liquidated damages. This means that the earnest money serves as compensation to the seller for the anticipated loss resulting from the breach. The seller can retain this amount regardless of its actual value, serving as a reasonable estimate of the seller's actual losses. However, this does not limit the seller's rights under other clauses in the contract related to property damage or dishonored funds. Breach by seller. If the seller breaches the contract materially, the buyer has two options. They can either terminate the contract and receive a refund of the earnest money deposit and due diligence fee, along with reasonable costs incurred during due diligence, or they can choose not to terminate and seek specific performance, which means they can compel the seller to fulfill their obligations. And attorney's fees. If legal proceedings are initiated by either party to recover the earnest money deposit, due diligence fee, or due diligence costs, the prevailing party may be entitled to recover reasonable attorney's fees. This provision encourages both parties to resolve disputes without resorting to legal action. As the losing party may be responsible for the other party's legal expenses. All right, page 14. The North Carolina Association of Realtors and the North Carolina Bar Association do not guarantee the legal validity or adequacy of any provision in this form for a specific transaction. This means that while the form is provided as a standard template, it may not cover all legal aspects or requirements of every real estate transaction. If you don't fully understand the form or believe that it doesn't address your legal needs adequately, it's strongly recommended to consult with a real estate attorney before signing. This ensures that you have a clear understanding of your rights, obligations, and protections under the contract. The offer becomes a binding contract on the effective date, even if the buyer fails to timely deliver any required fees, deposits, or payments. The contract can still become binding. Such failure may give the seller rights to terminate the contract as outlined in the contract terms or as allowed by law. So the buyer and seller sign and date here. Page 15, wire fraud. The agreement advises the seller on handling wire transfers for their proceeds at closing. It's recommended to provide wiring instructions in writing during the closing, preferably in the presence of the attorney. If the seller can't attend, they might need to send notarized instructions to the attorney's office. At least a call to the attorney's office with the wire instructions is essential. To prevent fraud, it's crucial to verify these instructions over the phone. Initiated by the attorney's office, the seller should use an independently obtained phone number for this contract, not relying on numbers from emails or agents. The agreement also mentions that wire transfers carry risks beyond the firm's control, and the seller releases the firm from liability unless caused by gross negligence. And page 16, we're going to have the buyer and the address, buyer and seller addresses filled in, and all of the information regarding the agents in the transaction. And then everybody is going to acknowledge receipt of money here. Everybody's going to sign. The escrow agent is going to sign. And that is it for today. So I am going to stop sharing. And I am going to open it up for any questions or comments. I'm going to stop the recording, and then we will open it up for questions.